Look at the facts, right? Even if the counselor had offered his belief unsolicited and just said to the client, like, I don't affirm these same-sex relationships as good personally, I don't think that would be imposing his values on a client in any coherent sense. Putting aside the fact that he did not offer his belief unsolicited, he was kind of imposed upon to express his belief, which is kind of ironic. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content here at Napa Legal.
And I'm Alexa Kawlewski, a recent graduate of Notre Dame Law School.
All right, thank you for joining us for this episode of the Napa Legal Podcast. For our listeners, now that Joseph has moved on to work at Alliance Defending Freedom, Alexa, who you may remember, I think she was on at least one episode last summer. She was one of our legal fellows, will be filling in as my guest host for the time being. So welcome back, Alexa.
Good to be back.
All right. Well, before we start, we will thank you in advance. If you enjoy the content we're putting out here on the Napa Legal Podcast, we always appreciate it. If you like the podcast, subscribe to the channel through YouTube or Spotify or wherever you happen to be listening from. All right. So this week we're going to be covering, there's some really interesting stories. First, we're going to talk about an Oregon therapist who was recently fined for refusing to affirm same-sex relationships during a counseling session. There are clear echoes of Childs v. Salazar going on here, a case which you'll probably remember because we covered it extensively when the Supreme Court weighed in on that earlier this year. Then we'll go to the Fifth Circuit and talk about an appeal regarding a federal rule that mandates employers accommodate abortion, despite the statute saying nothing about abortion. And then we'll finish with an interesting Third Circuit appeal by a Ukrainian Catholic church over a zoning dispute. Right, so let's start in Oregon. So the counselor in this case, his name is Frank Canepa. He's a licensed counselor in the state of Oregon. He had a client who was continuously pushing the counselor to affirm the goodness of same-sex relationships. Unclear why that was necessary in the counseling session. But the counselor was pretty clear that he generally tries to keep his personal views out of counseling sessions and focus on the client. But after being badgered apparently for like 20 minutes from the client insisting that he answer this question about the goodness of same-sex marriages, the counselor did eventually state that his Catholic faith prevents him personally from affirming such relationships. So in response to this statement, not surprisingly, a complaint was filed with the Oregon Licensing Board, accusing the counselor of violating the American Counseling Association's rule against imposing his values on a client. So he currently faces almost $90,000 in fines as a result of this alleged rule violation. And so now this case is in court. So initially, Mr. Canepa challenged the fines through an administrative procedure. I think the challenge started in 2024. He was ultimately unsuccessful. Now he's represented by a local attorney named Matthew Wand, but also by attorneys from Alliance Defending Freedom. And Mr. Canepa has appealed the decision to the Court of Appeals. So that's the intermediate appellate court, I believe, for the state of Oregon. I just want to point out a couple things. It's still fairly early on in the appeal process, but two things I wanted to know. That first, I think it's pretty clear that he didn't violate this rule, given the facts of this case. Want to make that clear. But then second, even if he had violated this rule, I think this rule as applied to this counselor is unconstitutional in light of Childs v. Salazar. So I think he should be successful on both theories. I just want to take a few minutes to explain my view of each of them. First, I would just say, look at the facts, right? Even if the counselor had offered his belief unsolicited and just said to the client, like, I don't affirm these same-sex relationships as good personally, I don't think that would be imposing his values on a client in any coherent sense. Putting aside the fact that he did not offer his belief unsolicited, he was kind of imposed upon to express his belief, which is kind of ironic. But telling someone your beliefs is not imposing your beliefs, right? I think it's a really disturbing trend that we see in modern secular society in a lot of examples, that if, a religious or a conservative person expresses a religious view of the world or of the human person or of sexuality, they're often responded to with, don't impose your views on the other person. But I mean, just think about this logically. How is hearing a belief that is different than your belief an imposition on you, right? Like I think of my own life. If a coworker expresses to me his belief that, for example, I don't know, sex is a social construct, there's no such thing as two immutable and complementary sexes, Thankfully, that doesn't happen to me in my place of employment. But if that happened, that's not a belief being imposed on me. Right? If the colleague then goes on to say that, well, if you don't affirm that belief that I've expressed, then I'll report you to HR and I'll try to have you fired, then that maybe becomes an imposition. But in this case, just saying a belief is not having it imposed on you. This is a very strange way to think about conversation and debate. So in this case, I think the counselor clearly falls into the former case. He's merely stating his belief when asked about the belief, by the way. There's no imposition. And ironically, right, if anything, the client was imposing his belief about same-sex marriage on the counselor because after demanding an answer and not getting the answer that he wanted, he goes and reports the counselor to the licensing agency. So if there's any imposition or coercion going on here, it's on the part of the client, not the counselor. Just wanted to point that out. As a threshold matter, I think even if you take the licensing rule here at face value, I don't think the counselor violated it. But even putting aside the very non-imposing circumstances in which this counselor expressed an opinion, I think that this rule against imposing one's beliefs, if it does apply to the counselor here for simply giving his opinion on a topic in the context of talk therapy, I think that imposing this rule on him runs squarely into the precedent set by the Supreme Court this year in Childs v. Salazar. So you've heard of this before if you're listening to this podcast or the kind of person who is familiar with the Childs case. But just for a brief review, in Childs, the court held that a counselor who is engaged in talk therapy was entitled to constitutional free speech protection. And if you remember, Colorado tried to argue here that its law encouraging LGBT ideology, right? You can affirm it. If people want to explore their sexuality, their gender identity, you should encourage that as a counselor. But if therapists try to help clients embrace a Christian understanding of the givenness of sex and sexuality, that rule, Colorado argued, was regulation of professional conduct and was only an incidental burden on speech. The court was having none of that. The decision was 8-1 in this case. Six justices in Childs simply held that this was an infringement on speech that warranted strict scrutiny. Justice Kagan wrote a concurrence that Justice Sotomayor concurred in, signed on to, which I think is relevant to distinguish this case, because Kagan and Sotomayor thought that, yes, this was an imposition on speech, but that it might be a different analysis if the speech restriction was content-based but viewpoint neutral, right? In the Colorado case, it was very much a law that favored and encouraged one viewpoint and forbid another. So that's viewpoint discrimination, and that's usually held to even stricter scrutiny. But in that case in Childs, only Justice Jackson dissented and argued that the regulation only incidentally burdened protected speech. So 8 of the 9 justices said, no, when you're regulating talk therapy by a therapist and the words that they're using in that therapy, that is a burden on speech, not just a regulation of conduct. So I think here the Oregon case is interesting because unlike Childs, you do have to make the distinction that I think the licensing rule here is likely viewpoint neutral. It's very vague in general, but it forbids the imposition of any beliefs of a counselor on a client, not just certain viewpoints, right? So I think at least in theory, if a counselor was expressing or imposing their beliefs in favor of like LGBT ideology, that also should be forbidden by the Oregon interpretation of this licensing rule. Although I would be curious to see if that licensing board has ever fined somebody 80 plus thousand dollars for expressing a positive view of LGBT ideology. But that aside, Childs had 8 of the 9 justices agree that licensing regulations like this that regulate speech of a counselor in talk therapy conflicts with the free speech clause. Only 2 signed on to that concurrence, making the viewpoint neutral distinction. So you have 6 justices that I think are pretty clearly like, no, if you're regulating the speech of a talk therapist, this is going to be a free speech problem. So I think for now I'll leave it at this. We'll follow this case. It's still pretty early on, but I think the Oregon case has a pretty high likelihood of being a victory for the Catholic counselor, and just in light of Childs v. Salazar and the First Amendment. So, Alexa, any thoughts on this case and what's going on here?
Yeah, I agree that it most likely is a clear case from the facts that are put out by the Oregon situation. Also, likely that they'll argue it falls more on the professional conduct regulation side, and they'll try to argue some sort of action rather than speech. But it seems pretty evident that it's speech that's at issue here, and the court has spoken pretty plainly about speech, even as recent as the last term. So I don't think this is a case that has potential for being a new issue in the area of speech regulation. Whereas if you had a different set of facts, you could potentially have a new case that would have a greater question of law.
Yeah, that's a good point. I wouldn't be surprised, given the makeup of the Oregon courts, if this goes poorly as it goes up the Oregon chain, which could be kind of interesting because it actually could tee up another SCOTUS case to actually confirm that no, even if it's a really pretty severe burden on speech that happens to be viewpoint neutral, that's still a problem under the First Amendment. So we'll follow this and see if it dies in the state courts or whether it continues to make its way up. So with that, let's move from Oregon to the Fifth Circuit.
So our second topic is about a Fifth Circuit hearing an appeal challenging an abortion accommodation regulation. So this starts all the way back in 2022 when Congress enacted the Pregnant Workers Fairness Act, which we'll call PWFA for short, to provide employment protections for pregnant women. Pretty basic, pretty nonpartisan. It was agreed on both sides of the aisle that they were reasonable accommodations employers should make to pregnant women experiencing physical limitations due to pregnancy or childbirth. So what they had in mind are things like altered work schedules, paid time off, additional bathroom breaks, things of the sort that pregnant women are dealing with, maybe right during their pregnancy or right after. Then nowhere in the text of the PWFA is abortion mentioned at all. So it's a statute that is silent on issues of abortion or anything sort of related directly to abortions. It's not in the text, which is very important to, I think, the rest of where this goes. But the Equal Employment Opportunity Commission, the EEOC, enacted a rule, so agencies can enact rules interpreting statutes that Congress has passed. They enacted a rule interpreting the PWFA, and their interpretation includes abortions as a potential accommodation. So that means that abortion is baked into the definition of pregnancy, childbirth, or related medical conditions. So you're assuming related medical conditions includes things like abortion, even though the text of the statute doesn't say that explicitly. And then the rule would prohibit employers from enforcing policies that prevent access to abortion, essentially by requiring employers agree to paid time off or certain time off restrictions for an employee to receive an abortion. Obviously, very concerning for a lot of religious employers and just organizations in general. And the upshot is that religious ministries, specifically Catholic ministries in this case, would be forced to support employee abortions in violation of their religious beliefs. So whether or not they're necessarily paying for them directly, the direct relationship is by at least allowing the employee the ability to take different parts of their job description, so different time off or different restrictions that they wouldn't otherwise have, simply for the request of an abortion, not for anything else, like potentially only for that, not even just because they're pregnant or something. So groups would have to change their ministry policies, statements of faith, employee speech, and what the EEOC also says their atmosphere accordingly to just fit this ability for employees to request this. So the USCCB, the United States Conference of Catholic Bishops, along with a couple of other Catholic groups, has asked the court to reconsider this abortion accommodation mandate, essentially, and to block it. And it has been stayed as of the current case. So it is blocked with respect to Christian and Catholic ministries currently as it goes through the court system, which is a positive result, but it won't be blocked completely until the court makes a decision about it. So the EEOC has essentially flipped the interpretation of the PWFA, the act that Congress passed, from what was on the floor to their own interpretation of what the text should say. One that includes an item, as we've mentioned, nowhere mentioned in the text of the bill. So Beckett filed a case in May of 2024 on this, and the lower court, which is the district court in this case, partially rescinded the mandate, but not on the grounds of the accommodation from a religious perspective. So it was sort of a half win. You could think of it as a half win, but it required that the appeal be filed in the Fifth Circuit to see if they could get a fuller ruling on rescinding the mandate entirely with respect to this issue. And it still required accommodations for most abortions, including what the court called those obtained to treat mild cases of nausea, anxiety, or changes in hormones, which, if you've ever known someone who's pregnant, applies practically to everybody. So it is like a universal statement that's not singling out really specific cases. If you can think of other abortion or related abortion acts where they'll single out cases of rape or incest or things that are not applicable to most groups of people and not widely necessary, but still in there as small exceptions. This is not a small exception, so it's not really an exception at all. It's a universal rule. And the court refused to enforce the religious freedom laws that shielded the ministries. So now it's on the floor of the Fifth Circuit, and the Fifth Circuit recently agreed to hear the appeal. So that's the update for the case currently, is that the Fifth Circuit will hear it as appeal from the district court, and then we'll make a ruling about the religious liberty issues specifically. So interesting to this case, kind of similar to the Oregon case, is that we don't only tee up religious freedom issues here, but you also tee up some speech issues, because employers would be unable to enforce life-affirming workplace values or statements, policies, practices, anything like that, against employees who would choose to obtain an abortion. So even if you can imagine a secular employee that's not necessarily directly tied to a faith tradition or community, but that has a specific set of policies that they adhere to as an organization, that they've always adhered to, they've always posted, things like that, but they would be still unable to ask employees to adhere to those policies in this case if the rule stood. So you have not only religious issues, but also greater speech issues. And employers wouldn't be able to communicate pro-life beliefs in any way that, quote, interfere with abortion accommodations, which sounds a lot like what we see in these speech talk therapy cases about imposing your beliefs on other people. You can't interfere with other people's decisions. And in this case, you're not even interfering to the extent that you're denying the employee the access to an abortion. The employee can still find access to the abortion. You're just denying some sort of additional time off or some sort of restricted work schedule or something like that in relation to it. So it's not even a one-to-one direct interference, if you could call it that, but they're still referring to it in that way. And this is not the first line of cases, as we know, where Catholic or Christian groups have turned to the courts to protect their religious exercise of religious beliefs when the government, or like in this case, a governmental agency, has demanded actions explicitly contrary to their teaching. To me, it's a cut and dry situation, once again, where you have a clear violation of religious belief, the exercise of a religious belief, especially because it's not actually what Congress passed in the bill to begin with. So being merely a decision by a governmental agency to bake into the law something that wasn't already there, and something that will impose a burden on religious organizations. It seems like the Fifth Circuit should rule one way on it. The Fifth Circuit tends to rule that way on religious freedom cases generally, but we'll be curious to see, especially in light of the district court in the Fifth Circuit's decision not to rule on the issue and to sort of decide it on other grounds, what the Fifth Circuit does with that.
Yeah. Yeah, I'm going to try to contain myself because there's so much wrong here. The first one I think is always worth pointing out because this is like a common theme of this podcast, is that these kind of secular laws that claim or ideologies that claim they just want tolerance for certain viewpoints or certain actions, I always kind of a red flag goes up there because the demand for tolerance very quickly becomes coercion and demand for like affirmation, right? This is not, we've heard for so long, like, just leave women alone, my body, my choice. If she wants to have an abortion, that's none of your business. And of course, that alone is problematic. But that's not what they're asking for here. Like you said, they're not saying stop, coercing us and preventing us from having abortions. Like, no, you have to affirm it. Like you have to give me time off to go get an abortion. You have to make sure that the atmosphere of the place of employment doesn't do anything that makes me feel comfortable, uncomfortable about these pro-abortion beliefs. So it goes from tolerance to coercion so quickly and so often that I think we should be very skeptical when we're just asked to tolerate bad things because then we're very quickly forced to affirm and celebrate them. So I guess the couple of things to just build on what you said, the two issues I'm focused on here are, for one, just the horrible abuse of regulatory power, because regulatory agencies have the ability, like you said, to implement rules that interpret or specify what is in a statute, not to make them completely different from what's in the statute. And this one definitely feels like a bait and switch. It reminds me a little bit of I know you use some of the talk therapy examples. What also comes to mind is like the Civil Rights Act era, right? Protections against sex discrimination. And then we go a few decades down the line and we get Bostock, where it's like, hold on, this was supposed to protect women from being discriminated against on the basis of sex, but now men who say they're women like are being protected by, like, this is clearly what nobody thought this law was doing when it was passed. This is just obvious. And I think here it's even more obvious because at least in Bostock, nobody was even talking about transgender ideology. So there's nothing in the legislative history. You just have to appeal to common sense. Like nobody thought that's what they were doing. But here we knew about abortion. And if I'm correct, I didn't look at the record, but I'm pretty sure that there's legislative history and debate that like congressmen on both sides of the aisle admitted that this doesn't touch abortion. Like this is not related to protections for abortion. This is about, yeah, pregnancy symptoms, childbirth, time off, things like that. So feels like a pretty sinister bait and switch that the statute's clearly not referring to abortion, and the agency has interpreted the statute to say what it obviously does not say. It's quite offensive to the whole system of how laws are made. Um, the other thing, I think it's really disturbing that there are intentionally pretty much no religious exemptions, which is fascinating. There are pretty much no exemptions to this, and that was done intentionally, I think, to avoid a First Amendment challenge, right? Like, there's some commentary I was reading that basically I was in actually it's in the transcript leading to the rule at the EEOC website around this rule that basically if they start giving some secular exemptions or some religious exemptions, then it becomes not a neutral, generally applicable law, and then they're subject to free exercise challenges and all that. So they basically gave no exemptions. But I mean, it's disturbing enough to try to create a work environment where employers have to celebrate an atmosphere that promotes abortion and all of that, but particularly sinister when you're forcing that application onto, right, like churches and religious organizations, probably even explicitly pro-life organizations. It's just so beyond the pale, and I'm curious to see where this goes. If this is something that gets killed at the Fifth Circuit, if this is something that's going to go up to the Supreme Court. And as you said, this could be decided a number of ways. You might not even touch, if this does go up to the Supreme Court or even at the Fifth Circuit, might not even touch First Amendment or RFRA arguments. This could just die on, like, this is an APA problem. This is not an appropriate rule based on the plain text of the statute. So um, to be determined.
Yeah,
Right.
especially considering that you have the added, I think, wrinkle in this case of really clear reliance on subjective belief or response of an individual to an organization's policies or standards. So you can imagine people taking this first step. Oh, you haven't affirmed that I would like additional time off to receive my abortion, to, well, you have posters in the office of fetuses in the womb, which is imposing your opinion about what a fetus is on me. So you have to take those down. And you can see the sort of spiral of you're going to just end up in these white walled rooms with nothing happening because the subjective opinion that you're always imposing something on me becomes this sort of all encompassing um, concern. And I don't think that that's where the court obviously wants to go. No part of the court. I don't think the appeals courts want to go there either. But you can see the if you draw this form of argument to its conclusion, where you would end up going from some of these cases.
Right. And that's one thing, that's a good point. It's one thing if you're applying that to like your office when you're working in a bank, but this could literally be applied to like a pro-life pregnancy center, which is
Right.
just such an absurd result. Yeah. All right. Well, with that, we're going to go to a little less of a hot button issue, but it's one that I think is timely, especially given some of the work we've been doing here at Napa Legal lately on land use, religious issues. So I just read about this article, this case the other day, and I happen to have some friends who are co-counsel on it. So I wanted to make sure we covered this. This is over in the Third Circuit in my home state of Pennsylvania. There's a Ukrainian Catholic Church, which we don't need to do too much background, but for those not familiar, it is Catholic in union with the Pope, but not a Roman Rite church. So the Eastern Rite liturgies, mostly ethnic Ukrainians, though not exclusively. My wife is Irish and French and grew up in the Ukrainian Catholic Church, so this is a particular interest to me. So this church community was in Western Pennsylvania. They planned to construct a shrine, a retreat center. It was a pretty big plan for use on its property. They acquired over 40 acres of property. For a long time, didn't have the funds to do too much with it. They were using it as a cemetery for their Ukrainian Catholic parishioners. But they got together the funds and made the plan and then proposed this shrine construction plan. I think the record wasn't too clear to me, but at least part of the property is zoned residential. I believe all of it is, but they were asking for like a use variance for at least 9 acres of this property from the residential zoning to do some of this work. A shrine, a retreat center, a parking garage to accommodate the people who would be coming, and some other buildings, all for religious uses, obviously, because it's a church community. So initially in 2024, the church went to the township zoning board, asked for the necessary approvals. The initial construction plan was denied in 2024. Then they had a scaled down plan, which was smaller, apparently less intrusive, I suppose, on the community. They scaled it down. They presented that in early 2025. The township denied that one as well. And then in June of 2025, they approved a version of the scaled down plan, but there were certain conditions. The chapel couldn't be more than 5,000 square feet. There was some other seemingly arbitrary conditions added. So in response to that conditional approval, the church originally filed a state appeal, right? If you don't like the result of a zoning board, you can appeal by right in Pennsylvania to the Court of Common Pleas, the trial court at the state level. They went to appeal the zoning decision, but then they withdrew the state opinion or the state complaint and then filed a federal lawsuit in January of this year, 2026, alleging that the decision violates RLUIPA, the Religious Land Use and Institutionalized Persons Act, as well as the First Amendment. Western District of Pennsylvania recently ruled against the church, so that's now been appealed to the Third Circuit where it's pending. It was kind of a sparse record for someone who's part of the public and not an attorney of record here. But I did read through some of the district court decision. I read the press release from First Liberty and the other attorneys who are representing the church. Again, it's pretty early on. We'll be covering this for sure because of our interest in this kind of religious land use work. But two relevant facts I think are worth pointing out for purposes of both the RLUIPA challenge and the First Amendment challenge. So, first, interesting fact, the attorneys for the church point out that less than a mile from the church property, so in the same zoning district, there's a carpenters union that has this massive 19-acre campus with very similar structures on it, classrooms, conference rooms, a large event space, a meeting room that holds 400 plus people for the use of it's a carpenter, like a labor union. But it's massive. I think it's actually bigger than what the church proposed, even in their first big proposal, let alone the scaled down one. So that's interesting. Second, the township's zoning code, and this is a real problem for purposes of RLUIPA in particular, the zoning code allows in this residential district several secular uses of property by right in that same zoning district. So it lists various secular uses, amusement parks, ice rinks, country clubs, fitness centers, but not allowing the same freedom for religious uses like what the church is trying to do here. So I think these two issues, the existence of that giant labor union campus and also the secular exceptions by right, are extremely relevant for both the RLUIPA and the First Amendment challenge. Um, so if let's start with RLUIPA. So under RLUIPA, this is the statute, by the way, in 2000. It was passed shortly after the Religious Freedom Restoration Act, a few years later, and it's meant particularly to protect religious land use from being discriminated against by local zoning ordinances and zoning boards. So there's a problem with the current interpretation of RLUIPA in that you need to prove that there's a substantial burden on free exercise of religion before the government has the burden of proving, their compelling interest in all of that. Um, the issue is as substantial burden is currently interpreted, at least in a lot of circuits, it can be pretty difficult to overcome that bar of the burden being substantial enough to trigger RLUIPA. A lot of courts simply will place a really high bar on substantial burden and um, you know, argue that, well, you could have come with a smaller plan, you could have moved it to a different part of the property that wouldn't violate the zoning board. There are a lot of conditions that a court can impose and say, well, the burden's not substantial because you can make it smaller, you can move it somewhere else, etc. If you're interested in this question, and again, it's not the non-discrimination First Amendment stuff that makes the news headlines, but this is becoming really important because it's a very practical way that anti-religious local communities can basically stop religious organizations from using their property for religious purposes. So it's an important issue. I think it's going to go back up to the Supreme Court pretty soon. In particular, if you're interested, I'd encourage you to check out the Missionaries of St. John the Baptist versus Frederick case that came out of the Kentucky Supreme Court and is now pending cert before the Supreme Court. Napa Legal co-authored an amicus brief in that case. I wrote it alongside our friends at the Manhattan Institute, where we argue particularly that the Supreme Court should fix the substantial burden test because it's stopping most religious organizations being burdened with land use ordinances from actually using the statute that was meant to protect them. So we encourage you to pay attention to that. And of course, if cert is granted, you will hear much more about this Missionaries of St. John the Baptist case in the coming months. But that being said, the RLUIPA test is different if the zoning action treats secular activities more favorably than religious ones, right? The analysis of substantial burden that I was talking about refers to cases where, hey, this applies to everybody, but in this particular case, if it happens to substantially burden religious exercise, then it triggers strict scrutiny. But you don't have to get there with the substantial burden test if the zoning or land use laws treat churches or other religious assemblies on less equal terms with non-religious assemblies or institutions. So I think that's pretty clearly going on here, right? For both of the facts that I pointed out. There's a giant labor union campus that's a secular purpose that had no problem getting approvals in the same district for pretty similar construction, large buildings, parking, all of that stuff. So there's a secular purpose apparently being treated more favorably than a similar religious purpose. That's an issue. And then also, like I said, there are secular purposes allowed by right. It's one thing if you just say, this is zoned residential one, right? If you're not a residential property, if it's not a single family home or a multifamily home, you need a variance or an exception of some kind. That would be neutral. But when you then say, oh, and by the way, in a residential one district, you can also build an ice rink or a fitness center, period, but there's nothing about religion, then you've crossed over from a general residential only requirement to something that I think is clearly treating secular purposes more favorably than religious. So I think you can actually get around the substantial burden test and just say, no, here you're discriminating against religion. And so RLUIPA comes in and you have a pretty high bar. The government has to prove some really serious reasons why they've accepted the labor union and they'll accept the ice rink, but they're not accepting the Ukrainian shrine and meeting space. So I think there's a really good case. And I would also note, though I don't think this is going to be the primary way that this case goes, but these facts are also relevant for the First Amendment analysis, right? If it's simply, again, a neutral, generally applicable law, like nothing that's non-residential is allowed in this district without a variance, then I think employment division versus Smith probably ensures that the church doesn't get strict scrutiny here, right? This isn't a free exercise clause challenge because there's a general neutral law. It applies to everybody. Sorry. Um, as unfortunate as that precedent is, I think it probably would stop it. But when the law in question treats ice rinks and fitness centers and all that more favorably than religious use of the same property, I think this is no longer a neutral, generally applicable law. And there's a good argument here that this is a carve out where Smith doesn't apply, and that maybe the First Amendment claim could go forward with strict scrutiny as well. So I would like your thoughts, Alex, but I do just want to shout out my friends at the Independence Law Center. So usually we're covering cases that are our listeners know the usual suspects. Almost every religious liberty case we cover, the lawyers happen to be from Alliance Defending Freedom, Beckett, First Liberty, Thomas More Society. Sorry if I'm forgetting any, but those are the most common stories that we cover. First Liberty is co-counsel in this case, as well as the attorneys at what are they called now at Troutman Pepper Locke, I believe. Um, but I want to shout out the Independence Law Center. They're amazing. Randy Wenger and Jeremy Samick are friends of mine. I've gotten to work with them on a lot of things over the years. They're Pennsylvania based and they do a lot of really heroic religious work, especially cases that originate in Pennsylvania. So they've been on this case from the beginning and always happy to see friends working on some of these big cases. So thank you all for your good work. Alexa, any thoughts?
Well, you mentioned that these cases, the zoning cases, don't make the news as much as the flashy First Amendment cases or abortion cases, which is such a loss because they have such interesting facts, often, the zoning cases. And I think even this case, you have a potential really fun opportunity to work with the facts and the history that apply to this specific plaintiff. So leaving aside that they grant the exceptions for the ice rinks and the, whatever, which clearly seems to be an issue from the religious use perspective, even if you didn't have that and all you had was that generally applicable residential one zoning law, you can still do a lot with the facts of these cases to display to the court how there has been a burden on religious exercise or how a generally neutral law is still being non-neutrally applied to religious organizations. And you see this often where you'll have examples like this where the religious group, the Ukrainian Catholic Church, has gone to the zoning board and the zoning board says, well, you need to do this and you have to do this and just come back and ask us again in a year. And it's really just this prolonged, drawn out process. And they're constantly asking them to change the plans or to change something small. And then you see the labor union go to the zoning board to ask for something quite similar. And the board says, sounds great, go ahead and get started. And it's very clearly a different approach that they're taking to two different kinds of groups and organizations. But they're using it, the same quote unquote law, zoning ordinance to do so. So you have a really interesting opportunity, I think, to draw out and really tell a story with the facts in these cases. But the story is often left behind some of the more nitty gritty legal issues that maybe aren't as interesting to the lay reader. But if you brought those facts forward, they could be just as interesting.
That's a great point. We saw something similar, echoes of Tandon v. Newsom, right, during COVID, where if you get the facts right and you tell the story, it's like, yeah, this is a, governor's state of emergency power case, not usually what makes the headlines. But then you start telling the story that like Governor Newsom in California is aggressively keeping churches and synagogues closed, but meanwhile, like they're opening everything else, and the Supreme Court steps in, like, yeah, you can't treat religion less favorably than secular endeavors. And so, yeah, similar thing here. When the labor union is like, "Yep, go for it," but the church and the shrine, like, no, no, you're not allowed here. Um, there's a way to spin that, and now you've got my mind going, and I think I know what I'm going to be writing over the weekend for for my next op-ed. There's a good way to make this a newsworthy case, and it's so important to stay on it because, I mean, talk about something that could really practically burden religious freedom, right? If this traditional Catholic group in Kentucky can't build a Marian grotto, or here you can't build a shrine in like really unobtrusive plot of land. This can render religious exercise pretty neutered.
Exactly.
All right. Well, with that, my first episode with my new co-host Alexa in the book. So, Alexa, thank you for being here.
Thanks for having me.
Yeah. So to our listeners, we hope you'll enjoy us and join us next week as we continue to highlight and discuss the most important ongoing legal issues that affect religious liberty, the work of faith-based nonprofit organizations. If you want to know more of what we're up to, you want to see the work we're doing, if you want to support us financially, that's always greatly appreciated so we can keep doing all of this fun stuff. You can check out what we're up to at napalegalinstitute.org. And also look out by the time this podcast runs, we will be opening registration for our nonprofit summit in Napa, California. That'll be Wednesday, July 22nd, right before the Napa Institute conference. So if you're going to the Napa Institute conference, spend the extra day, come join us for the nonprofit summit. If you're not, it's much cheaper to just come to ours than to do the whole big to-do of the Napa Institute conference. Either way, I hope to see a lot of you there. And with that, we'll talk to you next week. Thank you for joining us, and God bless you.